My name's David Combe. I'm a barrister at Trinity Chambers in Newcastle upon Tyne. And this webinar is going to look at the current October 2020 system of regulating business activity in response to the coronavirus pandemic. I'm going to look at two questions. Firstly, what is the scope of the three-tier regulation system? Secondly, how are the regulations to be enforced, principally by local authorities? So, the background. On the 26th of March 2020, the Health Protection Coronavirus Restrictions England regulations came into force. That was the legal basis for what has been widely known as full lockdown. On the 4th of July 2020, the regulations were superseded by the number 2 coronavirus regulations, which provided for a controlled resumption of social and economic life. The number 2 regulations have subsequently been amended, added to, and superseded in what has become a patchwork of law. National restrictions have eased and then tightened, whilst local regulation has been superimposed in response to local spikes in infection rates. On Wednesday, the 14th of October, 3 new sets of regulations came into force, having been laid before Parliament by the Secretary of State for Health and announced to the public by the Prime Minister on Monday, the 12th of October. And these regulations are intended to provide a coherent national structure, placing all local authority areas into one of 3 tiers. The explanatory memoranda to the regulations indicate that local authorities are expected to move between tiers according to the local incidence of COVID-19 infection. The regulations. The Health Protection Coronavirus Local COVID-19 Alert Level Regulations 2020 actually comprise 3 separate statutory instruments, which can be referred to in shorthand as the Medium Alert Regulations, the High Alert Regulations, and the Very High Alert Regulations. The new baseline for national regulation is contained in the Medium Alert Regulations. These apply to all local authority areas which are not specifically designated as either Tier 2 High Alert or Tier 3 Very High Alert local authority areas. The overall scheme of the regulations, I would suggest, is threefold. Firstly, it's to close some businesses. Secondly, it's to impose operating restrictions on a second class of businesses. And thirdly, it is to limit social interaction in accordance, broadly speaking, with what is known as the Rule of 6. Albeit the Rule of 6 is hedged around with a variety of exemptions, including not just childcare arrangements, weddings and funerals, but also elite sports, other sports, and outdoor activities. But my present interest is in the business restrictions. Regulation 3 incorporates the concept of a Tier 1 restriction by reference to Schedule 1 of the regulations, Part 2 of which is entitled Closure of Businesses. Paragraph 10 of the schedule lists the business types which are to close. These are described in the explanatory memorandum to the regulations as those venues where there is an increased risk of the transmission of COVID-19. And these are nightclubs, dance halls, discos, sexual entertainment venues, hostess bars, and any other establishment with a dance floor and music. Places other than nightclubs, sexual entertainment venues, or hostess bars may remain open, providing that the dance floor and music are closed and not operating. Part 3 of Schedule 1 of the regulations is entitled Other Restrictions on Businesses. This creates two sets of rules. Firstly, it provides for the closure of those businesses between 10 p.m. and 5 a.m. And secondly, it provides for a seated service rule. This seated service rule is itself divided into two parts. Businesses which serve alcohol must take orders from customers who are seated and ensure the consumption of food and drink by customers while seated. Businesses that do not serve alcohol may take orders from a standing customer, that is to say, queuing at a till, perhaps appropriately socially distanced, but again must take reasonable steps to ensure that those customers are seated while they consume their food and or drink. Businesses subject to Part 3 restrictions are listed in paragraph 15 of the schedule. They are restaurants, any businesses preparing food for on-site consumption, cafes, bars, pubs, social clubs, casinos, bowling alleys, cinemas, theatres, amusement arcades, fun fairs, bingo halls and concert halls. There are a variety of saving exceptions to these rules, and for example, these include a workplace canteen and a prison canteen. Tier 2, higher alert regulations. The next tier 2 is created by the high alert regulations, and these regulations are drafted in substantially identical terms to the medium alert regulations, save for Part 1 of Schedule 1. Part 1 is entitled Restrictions on Gatherings. And as has been widely publicised, this provides for tighter restrictions on social interaction, including to some degree what might be described as a rule of 2, applying to people who are not in the same household. Although again, this is subject to a variety of exceptions. However, returning to the perspective of business regulations, the more significant distinction is to be found in the very high alert Tier 3 regulations. At the present time, that is to say the 15th of October 2020, these Tier 3 regulations apply to a cluster of local authorities in the northwest of England, loosely surrounding the city of Liverpool. However, as I noted above, it is the expectation that other local authorities will be elevated to Tier 3 as and when local infection rates for COVID begin to spike. The very high alert, the Tier 3 regulations continue to provide for the modified Rule of 2 in relation to social gathering. But paragraph 17 of Schedule 1 of those regulations goes on to add materially to the provision for closure of businesses. It provides that all venues selling alcohol for on-site consumption are to close unless the sale of alcohol is limited to a drink accompanying a main course meal at either lunch or dinner. It can readily be understood that the broad intention here is to allow establishments such as restaurants to continue to trade and presumably maintain a margin for them to make some sort of profit, but to forbid what might be described as social drinking of alcohol. It's possible, of course, that in practice, the concept of a main course meal at lunch or dinner may leave room for questions of interpretation on a case-by-case basis, as those who retail alcohol for on-site consumption strive to bring themselves within the rules that apply. So, as I said at the beginning, the second issue that I want to look at is how these regulations applying to businesses may be enforced. Enforcement of the regulations is to be undertaken by a relevant person. A relevant person is defined in Regulation 4. It can be a police officer or a PCSO, or it can be an individual designated by the local authority. Local authority designation may only take place in relation to parts 2 and 3 of Schedule 1, that is to say the closure and restriction of businesses. And I would suggest that the task of business regulation is to be undertaken principally by local authorities. Offences. It is an offence to breach the regulations, which is punishable on summary conviction by a fine. Prosecutions may be brought either by the Crown Prosecution Service or a person designated by the Secretary of State under the regulations. And in relation to offences under the regulations, there is the familiar defence of reasonable excuse. This will doubtless be fact specific, and the regulations do not seek to further define the defence of reasonable excuse. It may be difficult, however, to imagine circumstances in which it will be reasonable for a business subject to closure, for example, to continue to trade in the face of the regulations. Liability in the case of corporate entities can vest in officers of the company, for example, directors, company secretaries, and managers. However, prior to prosecution, the regulations do provide two other enforcement tools. Firstly, under Regulation 2, a relevant person may issue a prohibition notice to any person who is reasonably believed to be in breach of the restrictions. The regulations specifically incorporate the concept contained previously in published government guidance that the action taken in issuing a prohibition notice should be necessary and proportionate. In my opinion, the reference to proportionality may imply that in many cases, a step such as the issuance of a prohibition notice should be an alternative to, or at the least a precursor to, prosecution. If businesses are continuing to operate when forbidden to do so, or operating in a manner that is inconsistent with the regulations, it is, again, I would suggest, difficult to imagine circumstances in which it would be regarded as either unnecessary or disproportionate to issue a prohibition notice. The form of a prohibition notice will no doubt be something that relevant persons will wish to consider with care. Notices provided for under the number 3 regulations previously for the closure of events mandated the requirements to be included in a notice. They aren't repeated in these regulations, but it may very well be wise to specify, firstly, the regulation pursuant to which the notice is issued. Secondly, the person or legal entities subject to the notice. And 3, the premises, venue, or activity which the notice is directed against. Additionally, Regulation 6 provides for an authorised person designated by the local authority or the Secretary of State to issue a fixed penalty notice. The effect of issuing a fixed penalty notice is to discharge from liability for prosecution the subject of the notice for a period of 28 days, and permanently if the fixed financial penalty is paid. For a first penalty notice, the sum in question is £200, although that's reduced to £100, a bit like a parking ticket if it's paid within 14 days. And for the second and any subsequent penalty notice, the sums double from £200 upwards to a maximum of £6,400 for 6th notice and all subsequent notices. Keeping in mind the concept of proportionality, it can be seen that except where the subject of a notice refuses to pay, they are likely to be a proportionate alternative to prosecution. So in the course of this brief discussion, what I hope I've done is given an overview of the ambit of the 3-tier system of regulation as it applies to business, as well as the tools for enforcement that are available to relevant persons, and in particular, I would suggest to local authorities. As I said, my name's David Combe, and my contact details are available on the slide that follows on from this discussion. Thank you.